Oh, yeah. You know, the keyboards are crying, guitars screaming. Somebody in Texas has the blues. Probably a good chance that our friend Judge David Fleischer probably gave it to him today. We'll see. Got about an hour and a half of a Fleischer docket ahead of us. And after that, if everybody's game, we got about 30-minute cut from, well, actually, the 30-minute cattle call from Judge Van, Bay County, Florida. Ladies and gentlemen, it's Blue's birthday. We're watching Fleischer. This is the Fleischer Forum. I'm your lone wolf Usul, and we're getting started soon. Stick around. Welcome to the Fleischer Forum, ladies and gentlemen. I'm your lone wolf Usul. Time to get started. I'm not going to beat around the bush. Like I said before, we got about an hour and a half Fleischer ahead. If everybody's game after this, we'll talk about doing some Judge Van in Bay County, Florida. But first, there's this.
All right, nerds, you ready? Let's roll.
Page 4.
Here we go.
Chappelle. Chapel.
Is it Chappelle?
Chapel.
Chapel?
Yes, sir.
Mr. Chapel, you're charged with unlawful carrying of a weapon. You're facing up to a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
Yes, Judge. The officer initiated the traffic stop after observing the defendant's vehicle without a Texas license plate on the front of the vehicle. During the stop, the officer observed an odor of marijuana and deployed K9 to conduct an open air search. The K9 alerted and the officers discovered 0.53 ounces of marijuana plus a gun under the driver's seat.
Mr. Chappell, do you have a Texas driver license, sir?
Sir.
Can you run this license, please?
Yes, Judge.
Are you on probation or parole at this time?
Sir.
Are you on probation or parole at this time?
Sir.
How old are you?
22.
What do you do for a living? What do you do for a living?
Work.
Where?
Amazon delivery. And your Honor, license is eligible.
How much money do you make a month?
A month, somewhere around 3,000.
Okay, we're gonna reset your case to give you time to hire a lawyer. I'm not putting any conditions on your bond, just be careful. Don't pick up any new cases. Don't drive unless you have liability insurance, car insurance. Do you have car insurance? Okay, don't drive unless you have it. If you do, then it's not gonna go well. Don't pick up any new cases. I'll have you go to Victoria, sign a reset. After that, we'll get you hired. When you come back, please have a lawyer, sir. Okay? Please.
All right, Judge, next is page 5, Cruz. Come on up. Go ahead and sign for your reception.
Speak English, sir.
Spanish.
Toma asiento, por favor. We need a translator for him.
Okay,
Just ask them again, just in case.
Not a big deal.
Okay, so.
Judge, the next one is page, it's another Spanish one, so that's it for now. That's another Spanish.
Okay. Hey, counsel. Coming up. Hey, good morning.
It's a little bigger, huh?
I know, right? Big change from,
Yeah, no, it really is. On Ariel Austin,
okay.
she just got her TRAS done yesterday. And this is the case, Your Honor. She is,
It wasn't done on, oh yeah, 11/4.
yes.
Okay. So you've turned everything in that needs to get turned in, right?
We have submitted the, well, I'm sorry, no, Your Honor. Waiting for her to execute the application so we can go ahead and submit everything to.
She's supposed to be issued here now?
Well, Your Honor, she resides in California. And what Your Honor had informed us was to get the TRAS done. She had got that done virtually.
Right.
And now waiting for the report so we can get the contract.
Nothing's gonna happen unless you've completely fulfilled your end of the bargain, meaning the application has to be done. You know, if, do you need a mitigation packet?
We've already submitted that, already received approval from Mr. Beadle. And so I guess at this point, we just need to submit the final documents to his team so we can get the contract and get everything executed. And
So how long is it gonna take her to submit?
we can get that done today, Your Honor.
Okay, so you wanna roll it just for a couple days to make sure everything's done?
Yeah, and I guess it's more so about getting her, because I wanted to get a date from her that will be convenient, but with respect to she will have to fly down here and for the final execution of everything.
I don't necessarily think so. She can
Okay.
still get the device out there, right?
Yes, you should.
I don't
Okay.
think there's a need for her to get everything, to
Oh,
really come
okay.
down here.
Well, no, perfect.
As
Your
long
Honor.
as she gets everything done in a timely manner, then I don't even think because she can get an interlock out there
Yes,
because there's a smart start out. She's in California.
yes.
We're in California, LA.
Yeah, in LA. That's
So there's a smart start in LA. All she has to do now, you're gonna probably have to go pay the DA fee for her though.
well, that's not a problem.
So let's set it, I guess, 2 weeks.
Okay, okay. No,
You know,
and
but
we'll
she-
see everything submitted today.
Right. Once you submit it today, hopefully they'll give you the application within the next couple of days. You know, she needs to, as soon as she gets the application, she needs to start calling around to make an appointment for the interlock.
Okay,
Okay? Okay. All right. Thanks.
thank you, Your Honor.
Take care.
Morning, Your Honor.
Hey,
How are you?
what's up?
I'm approaching off docket. It's cause number 253.
Okay, 253.
3581 Javier Marin.
Okay,
So I'm here at his request, Your Honor. This is not a drug DWI. It's an ethanol alcohol DWI. His bond conditions have him required to submit to random drug testing, and he would have to return to Houston when he's called in to do a test. I guess he's working.
no. What we have them do is they go take a test at a Quest Diagnostic wherever they're located. So where is he?
I'm not sure, Judge. My associate Al Valdez is actually the one who's working on this. His wife is likely giving birth today. So,
It's okay.
yeah.
So if it's called upon, he has to go to a Quest Diagnostic, which is a reputable lab, and it's his responsibility to get the stuff to us so we see the negative and then we're happy.
Right. And then I guess somebody from pretrial told him he needs to submit a 14-panel test for Quest Diagnostic for drug testing. He's just asking, Judge, if there's any way he could just do drug tests when he goes in to see his community supervision person.
But we don't know when that's going to happen, right? Basically, he'll be able to do whatever he wants and we'll never know.
Right. And the reason we're asking, Judge, is it.
One test. They're asking him now to take a test. He doesn't want to go take a test.
Yes, Judge, I guess he was just saying it was just kind of an inconvenience for the RUAs, and he was just asking if there was any way he could approach.
A second. If it was a first, I'd be more inclined to, acquiesce, but it's a second DWI. I want to make sure he's not using.
Yeah,
The only way
Judge,
I know-
it's just our logic is it wasn't a drug DWI.
I get it, but people still use. And I don't know. And I don't even have one test under my belt to see if he's ever been a negative,
Okay.
So he got called upon to do it. He hasn't done it yet. They're going to file a BVR and then I'm going to haul him in here.
Yes, Judge.
So please have him at least go get one done now. Just to have him go to a Quest Diagnostic wherever he is, get the results to you, get it to me, and then we're happy,
Absolutely, Judge. Could we maybe reapproach after he's maybe had a positive or a negative test or two?
You always can.
Okay, we'll do, Judge. All right.
I'm never going to, I don't know. I want to see how well he's doing. I don't know anymore. I don't know anything about it. I don't even remember what happened in the case, right? Was there an accident? Is it egregious? Does he have a 0.30, alcohol test? I don't know. So let's get a couple tests under the belt. That way we know we can trust him and then we'll go from there.
Sounds good, Judge. All right.
Okay.
Thank you.
Judge, I'll have to make an amendment in order to allow for that. I know I have to submit the semester through trial as well, just for our BVR sake. Would you like to-
When did they call upon to take it? When was he called to take a test?
I don't have any missed tests.
You probably don't have any tests,
Yeah, no, I don't.
but I think they just called him to take one.
Okay. He called about clarification on the 25th.
Okay, so it looks like they haven't even called him to take one. Just in the event that they do, have him go to a Quest, we'll go from there. It looks like there's no skin off his back anyways, as it is, right?
Yes, Judge.
Okay.
We'll do. All right, thanks.
Herman.
I have an arraignment on the docket. We're waiting for an interpreter. I have something that's not on the docket as well.
Okay.
I give you the case number.
Yes.
It is 250-7650. Yes, he's a gentleman. You wanted him enrolled in IOP and SOP. He doesn't live nearby. So Nathan said if he does that, then he can do a PTI, but he has to do all that first. He has to provided my office with the documentation and he has been enrolled. It is going to take some time, as the court knows, but you wanted me to come once he got in so we can get another reset.
So do you have proof of?
Yes, sir.
In the
Yes,
item?
sir. Yes, sir. I can show
So
you.
just make sure, if you don't mind showing this to Tori, so we can just verify it's the proper one, and then
Yes.
we'll set you off,
Absolutely.
4 weeks, just to make sure he's
Sure.
in compliance with
Yes.
it, and we'll come back, and then.
Yes, sir.
How long is the IOP?
Which providers
Let me look at the email, sorry.
It's 3 to 4 months.
Right. So what we'll do, Herman, is depending on how long it is, we'll do like a halfway check-in,
Right,
just to make sure that he's doing well.
it is with, Better Journey.
Are you familiar with that one? No? Okay. We'll sit you halfway
Sure.
and then we'll
Mr.
reassess.
Ramos is on your docket today, Judge. He's a Spanish speaker, but I
Is it-
understand he's
is that
over.
him?
Yes, yes. But he speaks, but I want to address something. His employer is here with him. They own an event company. Forget the lady on the right. And he's a driver for them. So I was hoping one or two things that with the interlock is just on his personal vehicle, as long as the employer, which he's here to vouch for him, he can drive that vehicle without, as per kind of like he doesn't have a commercial license, but under the occupational license, the statute allows it. But I was hoping the court either does something like that or just put a portable, which is more intrusive than the interlock itself.
I'm okay with that, Herman.
Okay, thank you. Okay, and I'll wait to
Personal, and then on the scram on the other one, so we know he's not, while he's in the other one.
scram. Can that be agency paid to scram? Sure. Okay, cool. Okay, so a portable and a scram. Okay, thank you.
And we'll pay for both.
Okay, thank you. And I'll just wait for the interpreter. And then, so he is allowed to drive as long as, yeah.
I mean, he has a
Yeah,
license
he has
and
a
insurance,
driver's
right?
license. Yes, sir. Yes,
You have insurance?
sir.
Okay.
Yes.
Counsel.
Oh,
Did
sorry.
you see that, Michael? Do you see who we're talking about?
No,
It's Ramos Amaya. So essentially, he wants the interlock only on the personal, not on the work, but we'll also do a scram to ensure that while he's, at no point, he's consuming.
But how are we gonna supervise him driving that vehicle, Judge? We don't know if he's, I mean, there's no possible way that the court can supervise and find out if he's intoxicated or has alcohol.
Scram's on his leg at all
On
times.
his
But
leg,
we
and
can't tell if he's gonna drive, Judge.
he is gonna drive. He's gonna drive his personal
understand,
vehicle
but
and the vehicle owned by his employer that she's here to vouch for the court, that he's not, he's not going to be driving with any alcohol in his system.
You can't vouch that he's not driving, he's not gonna have alcohol in his system, Judge. The only way we can properly supervise.
I'm not asking pretrial to vouch for it. Her employer, which is a reputable citizen, and she's here and here to
And
tell
that
you.
vehicle is he driving for? What does he do?
It's an event company, so it's those trucks that, they bring, the tents and everything for events.
I would be against it, Judge, just because we can't coincide the scram to when he's driving the car. So he could drink a beer and drive and the car would activate and we would have no idea.
It's
He would get a
excessive what they're asking for on
BVR
a first
eventually.
offender.
Let him-
I'm sorry, I thought he was done. Sorry.
He would get a BVR eventually, Judge, but there's just no way that the court can properly supervise him and ensure the safety of the community if we do it that way. I understand counsel's position, but I would disagree.
This is his livelihood, Judge. I mean, and he's such a great employee that it's very rare, as you know, when an employer
Yeah,
comes
absolutely.
in, that's how.
So, but why is it that the device can't go on the work vehicle?
Because it's a company vehicle, it's a,
It's a vehicle, though, right?
Yes, but-
Theoretically, it could, right?
but other employees drive that as well, Judge. I mean, it's just to put that burden on the employer is a bit excessive to have, that lady is a small business owner to incur that. And then you're gonna have other people driving it, and it can come back to Mr. Ramos's DVR as well.
No, because
No,
it takes your picture.
Yeah,
So
but
we
you
know
still-
if someone else, is consuming, which they shouldn't while they're working regardless.
No,
right?
I understand, but it's just excessive where he's gonna have a scram and he's gonna have.
I'll take it off.
I'm sorry?
I would take it off. I wouldn't, there's no need for a scram at that point if we put it on the work vehicle, right?
So,
I don't know, Herman, look, we're putting the cart before the horse because we haven't even found PC on it yet.
no, okay, I mean,
Let's really address it, and then I can always talk to her, and figure out, there's always a solution that can be worked, always.
okay, I'll just wait for the interpreter.
Do you have this is talk about?
No, we're talking about.
Which is this?
Interpreter's good.
Okay.
Can I call Mr. Ramos?
No, I haven't yet gotten a letter from them whether or not the insurance company has made a decision on accepting liability. So I talked to her earlier this week, was like, hey, can you try to
I can't admit it before. Morning.
Or Eric Ramos Amaya.
Yes.
order in the court?
Mr. Ramos Amaya, you're charged with driving while intoxicated. You're facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present during questions and interviews with the state of Texas. If you cannot afford a lawyer will be appointed to represent you, sir.
Yes,
Okay.
Judge. On October 28, 2024, the officer was dispatched to Hempstead Road in reference to a person down. Upon arrival, the officer met with a witness who advised that around 8:50 p.m., she observed the defendant's motor vehicle to be parked in a parking lot at Speedy's Fast Track and observed the defendant to be passed out
It's a safe place to stop, very well
in the
lit.
driver's seat of the car. The witness also observed the vehicle running. The witness attempted to wake the defendant, but he was non-responsive. Upon the officer's arrival, they also observed the defendant to be unconscious behind the wheel of the car with the vehicle running. Upon getting the defendant to exit the vehicle, the officer observed a moderate odor of an alcoholic beverage, glossy eyes, slurred speech, and a swayed stance on the defendant's person. The defendant admitted to drinking. Standard field sobriety tests were conducted, HGN, 6 out of 6, walk and turn, 6 out of 8, one leg stand, 2 out of 4. The DIC was read and the defendant consented to breath. The results were 0.228 and 0.221.
So you just found him there in the parking lot.
It was reported as person down. There was a call that came in. He was unconscious.
What kind of evidence is there that he was driving at any time? How do we know that he was not just hanging out at Speedy's and drinking
Well,
like
you're right.
crazy?
The officer found him unconscious behind the wheel with the vehicle still running at the time. And
I understand that. I understand, but maybe it was for warmth, so he could breathe. What evidence is there of driving? Do you have anyone that sees him driving? Do you have?
Your Honor, the witness just sees him parked already with the vehicle running, and that's what.
I
Yeah,
understand.
and that's what we have, is the call came in.
Michael, do you have anything else? You know?
Judge, so we have defendant unconscious in the front seat of the vehicle, and the court's issue.
He's in a parking lot of Speedy's. If he's in the middle of the road, unconscious, that's something, right? If he's in the middle of nowhere, unconscious, and he had to have gotten there somehow, okay. How do we know he wasn't inside Speedy's?
But Judge, my opinion is the court is attempting to litigate the issue. This is probable cause. All we have to show is that probable cause is met in the case. He is unconscious in his driver's seat of the vehicle while it's on. That, in the state's opinion, is more than enough.
Driving while intoxicated. It's not sitting in a car.
Operating a motor vehicle.
What proof do you have of operation?
I can provide you, if the court needs case law citations of operation and what is considered enough for operation. If you give me like 5 minutes, I can get
Take your
that for
time,
you.
no
Okay.
rush.
Thank you,
Really,
Judge.
we got until the end of docket. Show me something that says just sitting in a car,
Yes,
you
Judge.
know, with it on.
It's not a public roadway either. It is, yeah, it's a pub.
It's a public place, Judge. There's no case law.
I get that, but my issue is, how do we know that he wasn't inside Speedy's just going nuts on alcohol and he just goes back in his car and just sitting in his car to sleep it off? I don't know that. We don't operate on hunches, right? That's what I'm saying, like if he's.
Assuming that the state is correct in their case law, it still doesn't address your essential question. I mean, let's just say what they're saying for operation purposes. It still doesn't address that at the time that the officer said that found him, he was at 0.08 or higher, or any operation at all while he was intoxicated.
I just want some proof of operation.
I can get you the case log.
That's,
Yes, Judge.
I'm not asking much. All right, take a seat, Mr. Ramos. I'm not ready to rule yet.
All right, Judge, our next Spanish arraignment is page 5. Cruz, come on up.
Edna's here. Hi. Good morning. You are Luis Guillermo Acosta Cruz.
All right.
Sir, you're charged with failure to identify oneself by giving false or fictitious information. You're facing up to 6 months in jail and or a $2,000 fine.
Order in the court.
We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
Yes, sir. The officer observed a vehicle speeding 50 miles per hour in a 35-mile-per-hour zone and failing to maintain a single lane. A traffic stop was initiated and the driver was placed in custody due to the traffic violations, and the officer made contact with the defendant, the passenger of the vehicle. The officer observed signs of intoxication from the defendant, including bloodshot eyes, slurred speech, and poor balance, and the officer asked the passenger to step out of the vehicle because it was going to be towed. The officer asked the defendant to identify himself, and the defendant stated his name was Martin Sevilla Vargas, with a date of birth of November 16, 1982. The officer detained the defendant for public intoxication and identified the defendant with APHIS.
I agree, Judge.
Yes.
Whatever you're about to say, I agree.
I want to beat my head against the wall. I really just dunk. Mr. Cruz, I'm going to find that there's probable cause to go forward with the case. I want to inform you now that it's very possible that they charge you with driving while intoxicated out of this event. And I don't know why they didn't charge you with that as it is.
Judge, to be clear, this defendant wasn't in the truck. He was a passenger.
He wasn't.
He was a passenger. No, he was the passenger. Yes. And yes.
He was a driver.
No, and I'm dismissing the case.
Say that again?
I'm dismissing the case.
Which one?
The case you just found no probable.
You're on him. Did you find probable cause? Just for clarity.
I was going to find
no
probable
BC.
cause.
Okay.
I'm going with the state.
I thought that he was a,
Oh, no, Your Honor.
No,
I thought he was DWI.
so let me just break down to you.
Did you not say he was the driver of the
No,
car?
it was the passenger. The defendant.
I thought you said.
No,
He's a passenger. They detain him.
Maybe I need to go have like my head checked.
No.
He gives a false name. But they pull him out of the car, then they detain him for public intox after they're the ones that pull him out of the car. And then they APHIS him off of that. And then they find
I
him.
think there's enough probable cause to go forward on a failure to ID.
I think that technically he meets the statute, but I think that it was, I don't think that they had a right to arrest him for class C public intox after they're the ones that put him in public by pulling him out of the car.
Okay, I'm gonna find no probable cause. Today's your lucky day, Mr. Cruz. But I wanna impart something to you. If you're not in this country with permission, and you get in trouble, and you go to jail, and immigration finds you, they're going to put an immigration detainment. So if I were you, I would be on your best behavior, because the next time you might not get so lucky, and you could be very well spending the next 10 months to a year in jail. Do you understand? When you hang with dogs, you get fleas. Especially if you have a bunch of little kids that depend on you, a wife. Don't act a fool, because the next time I might keep you. You understand? All right, buddy, you're free to go. Thank you. Okay, ready, counsel?
Yes, sir.
Good job, Michael.
Judge, I have a Tina Perez, Perez.
Case 12.
Okay,
So Judge, on this case, the state completed the RIF earlier this week. I'm still trying to get a letter from the client's insurance company that they accept the liability, and
it's not too terribly old.
it's not. I think
Just
just
want to reset.
yes, sir. Yeah.
Yeah, I mean, it's 100 days old, so
Okay.
whatever you want, but it's gonna get up there soon, so if you die around,
I'm gonna have to do a pack for that right now. Judge.
just, get cracking.
Yes, sir. Yes, sir. Thank you, Judge.
Just leave it at that, whatever it is. Yes. Hey, do you have scissors?
Can you send me the case, please? See how I can stick. He says he has it. If we can send it.
He's ready to go?
Right, so there's multiple.
Now we lost the interpreter.
Oh, okay.
Oh, sorry. Okay. What's the, can you send me the?
So it's Anderson v.
Oh,
State.
can you send me the?
Yeah, I'll email it to you.
Anderson v. State, you say?
Yes, Judge.
What's the code?
I'm gonna send it to you right now. What is his client's name?
His client's name is. I think it's Perez. No, that's not. Sorry.
What's your client's name?
Ramos. Is that,
This is
it's the unpublished opinion?
Hold on.
maybe I'm looking at the wrong case. This is a sexual assault? No.
No, I think it's the 2010 case. George
26
Anderson,
It's a 2016.
It's 2016.
what's?
2016, you
I
say?
just sent it, yeah. I'm just trying to get the closest to what we have here in this case. There's multiple cases that,
Yeah, it's an unpublished opinion you're sending us.
sure, but the facts are very
Yeah,
similar.
but it's
not-
an unpublished opinion.
Okay, I mean, I can, if you want to give me more time, I can get more case law, but I mean, this is just something that I found in 2 minutes that is very similar.
Take your time.
Okay.
There's really, there's
Just
so much
email
we
me and I'll
have
come back.
until.
Got it.
No,
So give me some time, I'll shoot you an email.
there's just no rush. And then too, Herman, if you find something,
Yeah.
I don't want to impute. Please be seated. You don't have to get up. Mr. Harden. Yes, sir. Does anybody need anything before I go back? Anyone? Counsel, do you need? You need me for anything? No?
Your Honor, maybe. I'll confer with your coordinator first.
Who's your client?
Your Honor, it's Ernesto Gutierrez. May I approach briefly? Apologies to the court for not wearing a tie. I didn't think I'd have to.
I'm glad you made it. It's 160. I mean, we'll give you one more setting, but at that point, you need to decide what we're going to do.
Thank you, Your Honor. So, Your Honor, right now, I conferred with the state. He said most likely county time unless we could send over some convincing mitigation. And so he gave me his email.
Setting those, send what you have before the next setting, so that next time we can make a decision.
Yes, Your Honor.
He's got to take it or we're going to set it.
Yes, Your Honor.
Yeah.
Can I be excused? Thank you.
Okay, thanks,
He's
man.
got to be here at the next setting as well.
Thank you, Judge.
Hi.
Counsel for reset.
Good morning, Judge. I have Estrada on docket today.
Okay.
He's here. We actually extended his PTI. He wanted to make him come in to make sure that he finished the IOP, which he has completed IOP and he's registered for SOP.
Mr. Estrada, come up.
The SOP is expected to be completed January 2nd.
Okay. Anything else?
Fixed fees, it's like almost $1,000 behind. I don't know.
Good job on completing it. You're doing good. I mean, you're in the home stretch. I'm telling you, the amount of money you're gonna save by getting this thing dismissed is incredible, really.
I just want to thank you for giving me the opportunity to.
Well, just, you're doing good. Just keep it up. You know, the only other problem we have is that you owe quite a bit of money.
Yeah, which I'm gonna pay into the fees.
Once you, I mean, I can't quash it. If I could, I would, but I can't because it's their program. Just make sure you get it paid before January, because otherwise, you know, you're gonna sit here waiting, and the longer you take to pay, the higher the amount goes, you know? Because they tack on all kinds of other fees. It's crazy. So, okay, just don't drink. That's the only other thing we're asking, okay? Do you have, what's the expected completion date?
January 2nd.
Okay, all right, bud.
Judge, I did want to ask, he has a scram device and he also has a portable. Is it okay if we get rid of the portable because he's paying for both devices right now?
Yeah, I'm down.
Okay.
Oh, wait a second.
Just or,
Because is a condition of his agreement. The
well,
scram is not.
can we get rid of the scram?
Let me see which one is in the contract.
Okay.
It's gonna be a portable device. As a reward for doing well, I'll take off the scram device if we can, okay? And that should also help you with the fees as well. Just remember, don't put anything into your body unless you know exactly what it is. Okay, okay, all right, man, good luck. Hang tight. Hey,
May I take up a brief off docket matter?
for sure. What's your cause?
Judge, my cause number is 2533720.
2533720.
Here, yeah, it's Jose Arredondo, because we were here on arraignment the other day. In this case, there was an accident and my client didn't have possession of the vehicle because it was in the shop. Also, you know, candidly, there was a high BAC for like a 2.6. And so you ordered him to get a scram at that time. I wanted to see if you'd allow him, and if you ordered the scram because of the high BAC, if you'd allow
No.
just because of the no car or no access to the car business, but
Alex, tell me about it, will you?
So in this case, it was where the defendant was swerving between two lanes and onto the shoulder of the highway for several hundred feet. The traffic stop was initiated and the defendant was observed to have strong odor of alcoholic beverage, glossy eyes, and slurred speech. And he admitted to drinking 3 to 4 glasses of whiskey and 2 beers. And the officer was also told that he was inebriated. The defendant made the statement that he was inebriated. And the field test came back HGN 6 out of 6, walking turn 8 out of 8, one leg stand 4 out of 4, and the breath results were 0.264 and 0.252.
Any alcohol in the car?
No, Your Honor.
What do you want, just?
wanted to see if we could get him driving. The car's fixed, you can go get it. And so right now, because you didn't have access to the car, you ordered.
Does he have car insurance?
He does, and he's got a driver's license.
Say you on the license.
On the license, let me run his license, Your Honor.
We'll have to have an interlock before here.
Exactly, and I wanted to see if you'd let him either get the interlock or maintain the scram in the interlock or just the interlock. Okay.
Get it on the interlock, get it on the car, and then I'll drive. Okay, but he's got to get it on the car before he starts driving. Don't let him.
Well, I'm gonna have him, a family member's gonna pick it up from the
Yeah,
shop.
that's okay. We got it. Okay.
And he's
Just
eligible,
make
Your
sure
Honor.
you tell police that, so.
I have that all in his condition. There's no driving restriction, just when and if he is able to get access to that car, I do have him submitted to you guys. He just has to get that interlock within 3 days.
Thank you. Appreciate it, Judge.
Do you want to copy this?
So hard. Yes, sir.
Hey, Sylvia, how you doing?
Sorry to keep you waiting. Come on. Hey.
Good morning, Your Honor.
Good morning.
Mr. Robert Robinson.
Okay,
And that was gonna be an attorney.
do you mind bringing him up? Thank you.
Yes, he did.
Mr. Robinson. Mr. Robinson, you're charged with verbal harassment. You're facing up to 6 months in jail and or a $2,000 fine. You guys have worked out an agreement where they're offering you a 9-month deferred. A 9-month deferred, that is a type of probation that if you successfully complete it, you do not end up with a conviction on your record, but you must realize that you give up nearly every right known to man by entering into this agreement, promising us that you can make it. It's a contract that you're entering into. And if you violate this agreement, we can issue a warrant for arrest, put you in custody, and you'll be facing an entire 6 months in jail. You understand?
Sir.
For you to fulfill the agreement, you must do an effective decision-making class, a 2-hour anger management class, and no contact with Sierra Foster. Is this how you understand the agreement?
They do have children together. I'm not sure if there's some type of arrangement the court can make pursuant to a custody order or something. I'm not certain, but.
Do you have, is there a custody order with you guys now?
Yes, she's going against the visitation, so I don't see my kids. So it
You
is.
should get to see your kids, right?
Yeah.
And if you have someone that's playing with you that's not giving you access to your kids, you need to go get a court order, right? So when you do it, you go to a family court, you get a visitation order. So that way, if they play with you, you can either have them held in contempt, jailed, fined. There's all kinds of remedies that a court can do in your favor because you should have access to. Every child should have access to their father and their mother. They need you in their lives. So do whatever you need to do to get access to that child because they need you.
So
I'll make this deal even sweeter for you. If you are nice, you get it done quick, I'll take you off in half the time. All we're asking you to do is do your classes quick, be nice to everybody, don't create any issues, and I'll take you off in half the time. We do it all the time as a reward for you to get your stuff done early. Do you understand? Can you get this done? You give up a lot of rights by entering into the agreement. You give up the right to a trial, right to compel witnesses to testify on your behalf, confront and cross-examine your accusers. If you're not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization. You give up the right to appeal. So once you accept this agreement, you're in it until you win it or you get revoked. Do you understand?
Yes, sir.
How do you plead to the offense? Guilty or not guilty? I will not find you guilty. I will withhold that for 9 months. But like I said, get it done quick. We'll take you off quick.
Sir.
Tell me what you do with yourself these days.
Okay, can you say that one time?
What do you do with yourself these days? Do you work?
Yes,
Do you
sir.
at school?
Yeah, I work at a warehouse.
What kind of money you make?
Maybe 50,000 a year.
Okay, so we'll have you meet with Shatoria, so she'll go over all the stuff with you. Go get a visitation order, man. Those kids need you. That's the way that you do it. Don't take matters into your own hands because it's going to go sideways real quick. What I would do is use an intermediary. If you're not going to go get the order, get an intermediary. Your mom, her mom, someone else, even Mr. Holt here, Really? Some guys can exchange
Yes, sir.
there, but don't have contact with this person.
Yes, sir.
Because then it's really going to go back. All
Yes,
right.
sir.
But that way you guys can facilitate the,
Yes, sir.
transaction.
Yes, sir.
Okay, man. Good luck.
Thank you, Judge.
Thank you.
All right, come on up.
Yes, Mr. Aguilar, plead your honor.
Stop, you got it.
Yes, sir.
Jameson Aguilar, come up.
Judge, we sent Mr. Aguilar for a blood test this morning. On August 19th, he tested positive for THC, so you told him to test again in 30 days. So on the 24th of September, he tested negative. He tested again today, positive for THC.
What are you doing to yourself, Mr. Aguilar?
Oh, it's because I was riding with my cousin. He be doing touring. I mean, I've been clean. Just hit it one time. Accidentally.
So me putting you in jail one time is not enough to get you to stop, huh? I mean, what do we need to do? What are you doing with yourself these days?
I got a side job where I buy cars with my cousin, and I got a job too at Taco Bell. Taco Bell. Taco Bell. I showed you last time.
Taco Bell, got it.
The attorney. I showed him my GED because you asked for my GED, and I was working. I showed him I was working too.
You don't have any other goals in life? You're gonna work at Taco Bell for the rest of your life? You gotta do something with your life, man. This life is short. Keep getting these convictions, you're gonna end up going nowhere, man. Never making any kind of money. You do before us is killing it. All you keep doing is picking up cases.
Sir, I understand.
From now on, you are facing 90 days in jail on any cases that you pick up here. Do you understand?
Yes, sir.
If you continue to come back, I'm done with catch and release. I will not do it again.
Sir.
From now on, it is a minimum of 90 days in jail. If you're unable to stop, if you're unable to stop picking up criminal cases, 90 days. Do you understand, Mr. Aguilar?
Sir.
You're charged yet again with possession of marijuana. You're facing up to 6 months in jail and/or a $2,000 fine. You've worked out an agreement that's 3 days in jail, credit for the 1 day that you've done. You're giving up the right to a trial, right to compel witnesses to testify on your behalf, confront and cross-examine your accusers. If you're not a citizen, with possible immigration consequence, you can be deported, excluded from the country, denied naturalization. Like I'm telling you now, this is your theft. This is your third weed case. Now it reflects as a conviction, and from now on, it's 90 days in jail. Next time you're out in the free world and you're about to do something that you shouldn't be doing, think to yourself, am I going to be doing 90 days if I do this? That's what you need to be thinking. Do you understand, Mr. Aguilar?
Yes, sir.
How do you plead to the offense, sir? Guilty or not guilty?
Guilty.
I will find you guilty, sentence you to agreement. You will be required to pay court costs. If you don't pay court costs, you will be sitting in jail for every $100 that you owe. Do you understand?
Yes, sir.
Okay.
How much is it gonna be?
It's 205.
205.
All right, thank you, Your Honor. Thank you, sir.
Judge Amanda?
I am
approaching off docket on Damian Chu. This is going to be for an extension. Defense counsel is able. He's already agreed to a 2-day extension. Okay.
Thank you.
We approach on Ramos again. I don't know if you've taken a look at the cases that the state provided. They're very distinguishable, both of them. On one, the Prego case, someone actually sees the driver driving at some point, and then
I've read about 17 different cases.
right, and then the second one that the state has provided, there's the driver self-admits that they were driving at some point, and in both cases, they have the seatbelt on, and there's other evidence of driving and operation, which is distinguishable. In this case, there's no facts that he had a seatbelt on, or he was seen by anyone driving, or he ever admits to driving. So their reliance on those cases are unfounded because it doesn't fit this fact pattern that we have before us today.
So Judge, the first case that I'll refer you to is Prego versus State, which in that case.
Do you email it to me by chance?
I can send you an email right now, Judge.
That's the one he's seen, the person is seen at some point.
Can I make my argument, Counselor?
No, I thought you were emailing, yes.
I am, but let me
while
at
you're
least make
emailing,
my argument.
I wanted to give him a synopsis of the case.
Well, let me make my synopsis and then I promise you I'll let you respond.
I was in back reading, I must have read like 17 cases. God, I don't think that there was any case that supported your position. You know, I must have gone through at least 17 to 20
Well, they have to
cases,
prove
you know?
it's a totality of circumstances. Just behind the wheel is not sufficient. They have to provide. Okay.
So let's go to Kennett versus State, Judge. I sent you an email. Did you receive it? Okay. So in that case, I'm reading just word for word from the case. Courts interpret, quote, operation of a motor vehicle very broadly, and they cite Prego versus State, which is an appellate case. They cite Smith versus State, which is an appellate case. And they say, quote, while driving does not involve operation, operation does not necessarily involve driving. So we have to prove operation of a motor vehicle. Operation does not necessarily mean driving. It states any action that is more than mere preparation towards operating a motor vehicle falls under the definition of operating. So in this case, we have.
Does the fact that you turned the keys onto the car
Is enough, Judge.
That's his opinion. There's no case law that
That's
says
what the
that.
case law literally
You're saying
states.
mere
word
preparation.
for
like
word.
conspiracy, right?
Yes.
The law
Or
of conspiracy
law
is, it has to be more, like.
So
an
what did he
overt-
do other than start the vehicle? There's nothing more that there's nothing more than mere preparation. Here, it
And
was a
that's
hot
what-
day, and the Prego case, people see them, they have the seatbelt on, which is more than mere preparation. They don't show the seatbelt on. In the other case, the Houston case, it self-admits that they were driving. In this case.
Yeah, I mean, that's right. We're not gonna, if there's a self-admission, that's.
Right, and those
not
are what they relied on. The two cases, on the second case that he's quoting, or he's showed you on the site, that person, that defendant self-admitted. And there was also other evidence
Have you
beyond mere preparation.
You found any case law to support the position though?
Well, what position? It's their burden that there was more than mere preparation.
No, but I've asked you to see, because I went back and I literally read through 20 cases.
Yes.
And I can't find any case that supports the proposition that that's not operating.
Well, what they have to show is more than mere preparation. Having your vehicle on by itself is not beyond mere preparation. That is just mere preparation. They have to show either they had a seatbelt on, or the car was in neutral, or something beyond just in the car getting AC on a hot day. I mean, that.
If you can.
And Judge, there's no, you're right.
And, you know,
Right.
I'll certainly look.
I mean, that's what everyone, our legislatures tell us. If you feel like you should just stop and pull over, and that's what he did. And then someone comes at a later time.
There by your admission.
No, I'm not, because if you stop, turn off your car, and then you get hot because you're in a hot vehicle, turn it on, that's not operation. That is not beyond mere preparation.
Where are you getting that from? How are you saying that's not operation? What is your citation for that?
You just stated in your case law that you have to prove more than mere preparation.
Okay.
My statement is, all you have shown is mere preparation. That's it.
But
You haven't gone beyond mere
But to be
preparation.
clear, you don't have any legal basis for your opinion.
Yes, your opinion is right there when you said it's a totality of circumstances and you have to show more than mere preparation.
And I think the fact that.
There is no case law that says that.
Find me something.
Well,
different.
that case says it. That case says just turning on your vehicle, you have to show more than mere preparation.
That's not what it says. It doesn't
You
say
read
just
that.
turning on your vehicle is not enough. That's not what it says.
Is that Prego?
This is Kennett versus State.
And then that case is also
I'm
distinguishable.
gonna read it exactly what I read to you just a couple of minutes ago, Judge.
Okay.
Courts interpret operating a motor vehicle very broadly, and they cite multiple cases. While driving does not involve operation, operation does not necessarily involve driving, stating that any action that is more than mere preparation towards operating a vehicle falls under the definition of operating. So any action that is more than mere preparation towards operating a vehicle, that does not state that doing this with a key and turning on the car is not more than mere preparation. Our position is that that is more than mere preparation. You've put the key in your car, you've activated your vehicle. That is more than mere preparation. You're attempting to operate the motor vehicle. You don't need to be seen driving the vehicle to satisfy operation under this case.
I want to be clear. I'm not saying that it has to be seen, but they're stating exactly conversely what I'm saying. You're asking me to show you where just putting on the key is not operation. Well, I'm asking for them to prove just putting on the key is mere preparation, because they're stating a case where the defendant admitted to driving, okay, in that case. And that is in the facts of the case. And that's what the court relied on, that in addition to this law, that he admitted to driving.
You're saying in Kennett,
Yes, that
Admitted
defendant
operation?
took the stand and admitted that at some point she operated the vehicle. In the Prego case, someone saw that person driving the vehicle. Then they saw him at a later time
They admitted to driving at an earlier time.
Yes,
They didn't
yes.
admit to driving then.
Yes, that's correct.
Can you point to me to at least one case that shows me that where they have found it not to be operating?
No, but I'm also going to state this to the court. Can they show you one case where just having the key in the ignition is more than mere preparation? They haven't shown you that.
I went through 17 to 20 cases, Herman. I haven't found, I looked.
Either way, I bet. Either way, either way. So it's up to the
I
court's
didn't find
discretion.
any, yeah, I didn't find anything to support the position.
Theirs or mine.
So let's do this. I'm gonna find it for now.
Okay.
Go back, do some research.
No, there isn't. I'm very clear on the law. They have to show more than mere preparation. And they haven't in this case.
According to the case law, they have that.
No, I disagree, Judge, because because they haven't shown that starting your car is more than mere preparation.
I appreciate it, but the law says differently, you know? Come up, Mr. Ramos. Oh, do we have a translator or no?
And then we have the second issue, Judge, where we have a disconnect about, he
I know, and I'm gonna bring her up to talk about it.
Yeah, I mean, that's just ridiculous on a first-time offender to have where he did the right thing, even in the courts, pulled over and safely, and it was not a danger to anyone in this case, to have two interlocks put on one on a personal vehicle, on a commercial vehicle, where our legislature stated for an occupational license where someone's already been convicted, they can have it just on their personal vehicle and not on a commercial vehicle they're driving. So it's just excessive to have two interlocks, especially where she has multiple vehicles that he's gonna have to drive, where he's the manager of the events place, and he's all over all the time driving multiple vehicles, multiple trucks for him. And she has a strict policy of no alcohol.
Let me get the translator.
Sure.
I'm approaching for a reset on Valdez. The case is old, however, we don't even have an offer as of right now. The state wants to evaluate it. And the RIP call was just completed as of yesterday, so.
It was clear as trial. It says as of 9:30, you had an offer.
Well, no, I don't have an offer. And like I said, the RIP call was just completed yesterday.
Guys, do you have an offer in Valdez?
Judge, this was a 2B case, so even though the offense happened last year, he wasn't.
I get but it's still 190 from the time that he's been arraigned with us.
So we just were able to make contact with the complaining witness finally yesterday, and I spoke with her, and she said that she had just signed an affidavit of non-prosecution with the defense like 2 weeks ago. Defense had not advised us of that, so I just need time to do an eval and see if I can prove it without her. So I just need to listen to the 911 calls.
Do a week. He's got to be here at the next setting, because by then it's over 200 days. We got to figure out what we're going to do. We'll give you a week, okay? And then in the interim, if you can put an offer on the case as well. And then he has an open aggravated assault, same complaining witness as well?
No different.
Okay. All right.
Thank you, Judge.
Yes, ma'am. Ma'am, come up. Okay, Mr. Ramos, I've been.
Order in the court, please.
I'm gonna find that there's probable cause to go forward. I am already used a condition, but well, let me ask you this, are you a United States citizen?
No, no.
Are you in this country with or without permission?
Judge, I always tell my clients that it's not to answer because you're asking them to admit to a potential criminal.
Okay.
Yes.
I want you to understand, one thing. You're not in this country with permission. You go to jail and immigration finds you, they will put an immigration detainer on you and you will be stuck in custody first until this case is over with and then shipped off to immigration. I don't know what your immigration status is, but if you're not in this country with permission, be very careful. Do you have a Texas driver license? Do you have liability insurance in your name?
Yes.
Okay, you may continue to drive, but I am ordering you not to consume alcohol or illegal drugs. I will randomly test you. If I find that you're consuming alcohol and any kind of illegal drugs, I will put you in jail. You will not get any more PR bonds. Now, I will order you to obtain an interlock that you're not allowed to drive any vehicle that's not equipped with an ignition interlock on it. Your counsel has asked me not to put one on in the work vehicle, but understand that could be a huge liability on your part. If there's an accident and they learn of that he has an open DWI, it could be potentially disastrous to your business. So you need to consider this when you're out there, especially if he's driving and he has an open DWI, it could be very disastrous.
Are you saying that he's allowed to drive one of her vehicles without an interlock?
I know that you are against this, right? What I will do is I'm also scram monitor on your ankle, so I know that you're not consuming alcohol at any time, and I will not put it on the vehicle, okay? But I want you to understand, these machines are extremely finicky, so you better darn well know anything that you put in your body before, because I don't care what it is, if it's a tequila lollipop, if it's NyQuil, if it's hair dye, if it's isopropyl alcohol, if it's Jesus comes down and tells you to break bread, I don't care what it is. The slightest, faintest, most remote positive alcohol, you will land in custody. Do you understand? Be careful, especially with your insurance, because if insurance knows that if your insurance doesn't know that he has an open DWI and it gets into an accident, they may deny liability. So, you need to really put everyone on notice, because it could be a very big issue. Now, good job on having a lawyer. You've got a junkyard dog for a lawyer who we respect very much. It is your responsibility to stay in touch with Herman. He will tell you if and when you have to come back to court. If Herman tells me that he can't get a hold of you because you're playing games, I will issue a warrant for your arrest. Just stay in touch, do not pick up any new cases, and don't consume alcohol. Do you have any questions?
No.
I will also pay for the devices so that there are no issues, Herman.
Okay, thank you, sir.
Do you have any other issues?
No, sir, not at this
Okay.
time.
All right. With that, we're done.
Thank you.
All right. John D.
Judge, my reapproach on a.
Carla, I'll hit you next. Chat me what you got, huh?
Oh, Your Honor.
Yes, sir. Thank you.
Judge, may I bring up Ms. Scott for a time served plea on a DWI? All papers are in, Judge.
Beetle.
Yes, Judge. Good morning.
Welcome, you know the honor.
I was across the hall.
Oh, no. Are we in trouble?
No, I was visiting Elizabeth Russell. I don't know if you know Elizabeth Russell. She started yesterday, it was her first day, but she started with me 23 years ago. And she's had a family to come back to work. She was a great trial attorney. She looks exactly the same. She's just more experienced. So I was not in the office yesterday. I was teaching at the academy. So
Take time, we'll meet. You said, John D.
Ms. Scott, for us. Ms. Scott, can you approach, please?
So, John D., no intervention?
I'm sorry?
No PTM?
Nope, not just, went all throughout, you know me, Judge, I go through all that.
Ma'am, you're charged with driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine. You've worked out an agreement that they're offering you 3 days in jail, credit for the 1 day that you've done. You need to understand that this charge will go on your record. It will be there for the rest of your life. It's even there after you die. It's important because if you ever get pulled over in a car and you have the smell of alcohol, officers will look, they'll see this. What do you think they're going to do to you if they smell alcohol? Right. What we're doing today, from now on, you are facing a minimum of 30 days in jail. No more proverbial slaps on the wrist. So if I were you, even if you've had a sip of alcohol, I wouldn't get into a car because you can be facing a lot of time. You understand? You still want to do this? You're giving up the right to a trial, right to compel witnesses to testify on your behalf, confront, cross-examine your accusers. If you're not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization. You give up the right to appeal. Once you plead guilty, like I said, you can never change this. You sure you want to do this? Why not the intervention program to get it dismissed?
She had I think it was an evading back in 2023, and previous, her blood alcohol was like 0.29. It was way up there. She didn't want to have to go through all the medication.
Wait, she's a prior DWI? A prior DWI?
No, like evading. Back in 2023, she's already got a criminal record. I talked to her about that.
32.
Yourself now?
I work.
Doing what?
I work at Burns Barbecue, it's a barbecue place.
So no, you don't want to try to get this thing dismissed, huh? All right, ma'am. I'm going to suspend your license for 90 days. Do not drive until you get a license. What kind of money do you make?
I get paid every week.
And how much do you make a month? Maybe 5.
I'm here, Judge. She got me.
Yeah, that's the question, is how did she get a court-appointed lawyer? Because you shouldn't have qualified for an appointed lawyer.
Can you fill out the financial affidavit?
I had 2 jobs at the time. I was working Waterbury as well.
So you have 2 jobs.
Well, I had 2 at the time.
So you don't have the same?
No, I only have 1.
Because the judge is like.
How long have you been working at the place?
10 years, since 2014.
You don't have children?
No, sir.
In order to pay the fines and fees, man, you know, I mean.
For DPS purposes, or, I mean.
You're gonna be required to pay the fines and fees, man. You don't qualify. You didn't even qualify for him. Put something completely different on the affidavit.
No, I had 2 jobs at the time. So
Oh, so you make even more money.
No, I had 2 at the time. I filled out the paper at the time. Now I don't.
You don't have to.
For 10 years, you make
shooting yourself.
$5,000 a month.
No, it's not actually how much it is.
Well, you just told the
That's
judge that right now you're making $3,000 with 1 job.
No.
Okay, well, that's what you just told him. How much do you make now? That's what he asked you. Okay, you just told
I only
him.
make like $200 and some after taxes, like 3. It's no more
You
than
mean
$300 a week. Yeah, $300 a week.
So why did you
What's
tell him
that?
$3,000 a month a while ago? That's what he's concerned about. Judge, I think we have a
I mean, after you round
miscommunication.
it-
You
round
make
it off, it
$300
probably
a
like
week.
2,000, so.
No, hold on. You make $300 a week. Times 4, that's about $1,200 a month.
I just want the truth.
I can show you check stubs.
I asked you how much you made.
I
You
think she
said,
was-
you know, $4,000, $3,000 to $4,000 a month, you know?
Talking about a week now. You were thinking about a week.
Yes,
So
I
you
don't
make $300 a week.
John, I'm not.
Can I get proof and come back and revisit it, Judge? Because can I get proof and come back and revisit it? Let's do that.
Look at my purse.
Yeah, she says she has proof in her purse, so let me look at it and then I'll come back and then before we go. Okay, no worries.
Cesar Hernandez. It's a case that it's kind of old, but they're trying to gather the mitigation evidence. And if they're asking
I'm gonna give him 2 weeks.
All right, yes, sir.
I'd have everything done because it's 180 days. He's
No,
supposed to be here with the stuff. So 2 weeks, he's got to be here. If he doesn't have it done, if he's got everything done to turn in, we'll send it to the TRAS.
All right, thank you, sir.
And have absolutely everything to turn in by the next set.
Yes, sir.
Okay. Thanks, Rob. Okay, Darla.
Yes, Judge.
Tell me.
I have a client that is a to be warrant. I believe he is in your jury box.
Okay, I see him.
We're trying to see if we can get a PR bond on his case and
Okay.
then alternatively a walkthrough.
William Jones. Coming up, Mr. Jones. Alex, did you get the cause number?
Yes, Your Honor.
Okay. Did you get it, Steph? It's 253-5048. Mr. Jones, you're charged with driving while intoxicated, second offense, and it's elevated to Class A. Well, it's elevated due to the high blow, so you're facing up to a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present if you cannot afford one. One will be appointed to you, sir.
Have Ms. McBride.
Yes,
Okay,
Judge.
please.
The officer was dispatched to a public street in Pearland in Harris County, Texas, in response to a crash. Upon arrival, the officers met with the witness, the defendant's wife, who stated that she was tracking the defendant's location on her phone while he was driving home from a diner and noticed that the car was stationary for a long period of time. When the witness arrived at the scene, she saw the defendant standing outside his vehicle, and the defendant told the officers that he made a wide right turn and hit a parked car. EMS arrived and began examining the defendant. EMS asked the defendant if he had consumed alcohol, and the defendant admitted to drinking 7 whiskeys. The officer stated that while speaking to the defendant, he observed an odor of an alcoholic beverage. The officer began DWI investigation while en route to the hospital. Standard field sobriety tests were conducted, HGN 6 out of 6, and walk-in turn and one-leg stand were not conducted due to the defendant being strapped to a gurney. The officer obtained a search warrant, and the blood alcohol was 0.16.
You said there was a witness that saw this, right?
A witness who was tracking on his phone, seeing the vehicle station.
You also have a witness who saw the traffic infractions, right?
So it was an accident where he had hit another car. We don't have another witness
This
that
one.
actually saw that yet.
All
If I may, that the witness they're referring.
Stop.
It's okay. We'll fight that battle whenever it's time.
Okay.
Anything you say they can use against you, just don't. Not a lawyer. Ms. McBride can do everything for you. So, Mr. Jones, I'm going to find that there's probable cause to go forward with your case. I'm ordering you as a condition of your bond not to consume alcohol or illegal drugs. I'm going to randomly test you. If I find that you're consuming alcohol or kind of any illegal drugs, I will revoke your bond, put you in jail. No more PR bonds for you. Do you understand?
Yes, sir.
Do you have a Texas driver license?
Yes, sir.
Do you have liability insurance in your name? You're not allowed to drive unless you have both. And I'm placing now an additional restriction on your license. You're not allowed to drive any vehicle that doesn't have an interlock on it. If you're caught driving a vehicle that doesn't have an interlock, likewise, you will go to jail. You will not get any more PR bonds.
Interlock.
It's a breath test device that you will put in your car that does not allow you.
Where do I get that?
I have pretrial services here that will help you with the paperwork and how to go get it done. I'm now just telling you, we will also provide paperwork to the Texas Department of Public Safety so that if you're
Okay.
caught driving a vehicle that doesn't have an interlock, officers will know and they will put you in jail. So just beware that eyes are all around you and everyone.
And also, I just want to make a point that this is the policy of the courts to order it. There's nothing that I can do or say to make you not order the interlock on a second.
On every second DWI, we do that. So it's per statute. Morgan, did you want to add anything? You came up here, usually it's because you want to.
No, Judge, I just thought it might kind of sound confusing. I just wanted to add.
Okay, thanks. Now you have a lawyer. It is your responsibility to stay in touch with the lawyer, and she will tell you if and when you have to come back to court. If Darla tells me she can't get a hold of you because you're not responding to phone calls or text messages, I will issue a warrant for your arrest.
Okay.
Now let's talk about the bond, Darla. I don't see a bond that's been set. Alex, do you have a recommendation? And I need a PSR actually as well, you know? Do you mind? Let's do a PR bond. Mike.
Opposed to a PR bond.
I don't have his criminal history. The only thing I see is a DWI from 1989. You know, back when Margaret Court was famous.
Yeah, Judge, I mean, just given, we would be opposed, just given the nature of the offense is a major crash. He admitted to drinking 7 glasses of whiskey, he had above a 0.15, so just.
What's your opinion is still a bond amount?
I mean, I would, nothing set. Oh, it's not set at all. I would ask for 1,000, sure. I would ask for 1,000, surety, Judge.
Darla, what do you think?
I mean, 1,000 is fine to have a number set, but we would ask for the PR bond to be granted. I mean, I think 6 years old when he picked up his first DWI. He hasn't had any, significant interactions with police officers since then.
Do you have any criminal history from back then until now?
No,
Or just briefly run this history, Judge.
Yeah, please.
Your Honor, may I address the court?
And it's more so to protect you, because I don't
Yes, sir.
want to say something that you, when you think you try to help, you may invariably put the proverbial foot in the mouth.
Yeah.
It's just now is not the best time.
No, Judge, there's no other criminal history.
Okay. It's been a while. He's not been in trouble. I mean, I believe everybody deserves a chance, and I'll give it to you now. I'll give you a PR bond. But like I said, you're not going to get another one if I find that you start acting up or you endanger my public in any way. I will put you in jail, and I'm going to make your bond extremely high.
Thank you, Your Honor.
Okay, so I'll set the bond at 1,000. Darla, I'll grant you a PR bond. We'll have him meet with pretrial. We'll have you sign a reset as well. And then if you just hold tight for me, we'll have you out here in about 20, 30 minutes. Okay, thank you, Mr. Jones.
Hey, Judge, how's January 14th?
Darla.
Looking at it now, January 14th.
Through the 16th.
Okay, I can do January 14th. I'll be right across the hall.
All right.
All right, see you then.
Thank you, Judge.
Take care.
You too.
Sign the internet so I can give him a copy.
Yeah.
All right, go ahead and sign for your reception.
No, that's an interesting haircut.
Just can I approach real quick on this?
Yeah.
Judge, she was confused. She was thinking that you were talking about on a weekly basis. I have her check stub. She makes $300 a week. So she makes about $1,200 a month. She has to pay rent, which is about $400 or $500. She lives with her sister, her food, transportation. She was thinking, I don't know, she said she was nervous, she wasn't thinking straight, but here is her pay voucher, Judge. So, I mean, that's the sure thing. You can take a look.
Trust you, John. I trust you. Let me do this real quick while that. Is this your client?
Yes, Judge, this is Mr. Alexander Argueta. And Luis is here as well.
Morning, Mr. Argueta.
Good morning.
Mr. Argueta, you're charged with assault of a family member. You're facing up to a year in jail and or a $4,000 fine. I got it. Yes. It looks like you've worked out an agreement. They're offering you 3 days in jail. How much?
Oh, sorry, 62 days.
It's 3 days in jail. Credit for the 62 days that you've already done. You need to understand a couple very important things, Mr. Argueta. One of the things is that this comes with an affirmative finding of family violence. What that means is that if you ever pick up another case like this, and it doesn't mean that you have to beat someone down into complete submission. If you just grab someone's arm and slightly squeeze it to where it hurts, from now on, you will be facing a 3rd-degree felony, a minimum of 2 years in prison, a maximum of 10 years in prison. You can also never own a gun or ammunition as a result of this plea bargain agreement as well. You pick up a gun, that in and of itself, you're facing a year in jail. Do you understand? You're giving up the right to a trial, right to compel witnesses to testify on your behalf, confront and cross-examine your accusers. If you are not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization. You give up the right to appeal. Once you accept this agreement, you can never change this. It will be like this forever. How come he's still in custody, Ricardo?
Judge, there was a concern regarding his competency. There's a concern regarding his competency.
Okay.
And so, once we got to a point where we got evaluated and we started working on a deal, started working on options, and so this is as soon as we were able to make it happen after the competency.
Are you, Mr. Argueta, do you take medication?
Yes.
What happens when you don't take the medication?
I stay sleeping.
No. No. When you don't take the medication, end up in orange. You have a lot of cases, you have a lot of violent cases. If you take the medication, good things happen. Just keep taking it. And you probably won't wear orange anymore. How do you plead to the offense? Guilty or not guilty? I will find you guilty. I will send you the
Judge.
Not guilty.
You said not guilty.
Dijo que no es
Not
culpable.
guilty of this. Are you guilty of
¿Es
this?
culpable o no es culpable?
You're not guilty?
No es culpable.
We can set your case for trial.
Podemos
Hey,
poner su
is
caso
discovery
perdido.
complete?
Your Honor, looks like we're still waiting on the writ for the complainant.
Judge, would you allow me an
Actually,
opportunity to speak with my client to see what this is about? We previously spoke, I'm not sure if he's confused or what's going on, but would you allow me an opportunity to talk to him, see what he wants to do?
Mr. Argueta, it's not a game. If you're truly not guilty, don't plead guilty. Okay? I'll give you time to speak to Ricardo and then you guys let me know.
Let me inquire, see what's happening. Judge, with this proof, will you find her?
Come up, man.
Yeah, you can have it. You don't need to see this.
That's too much. All we want our streets to be safe. And if you continue to pick up DWIs, you're either going to end up in jail, prison, or you're going to end up dead. The reason I ask you these questions now is because one of the things that you have to do when you pick up a DWI is you have a lot of fines and fees. One of the things that you are required to pay is a DPS surcharge. That surcharge is $3,000. If it's above a 0.15, it's $6,000. That's why I'm asking these questions to see if you were indigent or not. And if you're indigent, more than likely what I do is if there are no issues, then I waive the fines and fees and surcharges and the court costs. But you're telling me that you make $3,000 to $4,000, and then when I say, oh, about $5,000, you shake your head, yes. So which one is it? How am I supposed to know? So I have a big issue because now I don't know what to believe. The only thing I'm going to tell you is this. I will give you the benefit of the doubt today, but I'm not going to do it again. On a second DWI, your surcharges will amount to around $7,000. So if you are not smart enough to consider how to get home like a little child, we will put you on our knee and spank like a little child. But we do it with a ton of jail time and a humongous financial hit. Do you understand? All we want our streets to be safe. And if you want to get lit, great. Just hit one small button on your phone that gets you a car ready to take you anywhere you want to go for $20. It's a geographical oddity. Understand? Good luck.
Thank you, Judge.
Thank you, Johnny.
I had one other, Mr. Sturgis, who was supposed to be here because he was to bring proof of work, but he's.
You know home?
Page 16.
You know home?
Is that, okay, I just wanted to know.
1 million, what page? 16. Yeah, 5,001. Michael Fan.
Just good morning, Your Honor. I'm here, Mr. Pierre Simon. He's scheduled for court today. He's at the interlock. He's getting his device installed. We're asking the court if we can just roll him for Thursday. He's going to pay the entry fee and get in.
This time we came back and we told him if he didn't have it in, we roll it day for day.
What's the last name?
Pierre Simon.
You know, Michael, I'm going to tell you that, and I'm going to make notes to this, that what we have found when it is very difficult for someone to get into the PTI program, 90% of the time they come back with issues. I hope it's not with this person, and I want you to let them know.
All right.
So when do you want?
Thursday, Your Honor.
And he's actually supposed to be here now.
Yes. He's at the interlock.
How do I know that? How do I know he's not dilly-dallying elsewhere? Really, I don't.
Yes.
You know? No, I'm gonna revoke his bond. If you show me proof that he's actually at the interlock place now, go FaceTime him.
Can you roll for tomorrow? Can you roll for tomorrow and then we'll get he'll have the entry fee and the contract.
100% positive he's there right now?
Yeah, I believe he is, Your Honor.
Did he tell you or how do you know?
He told me.
All right, I'll SFBF tomorrow.
Thank
He
you, Your Honor.
better have it done or his butt better be here. Because if not,
If he has it done, can you waive his appearance? So that way he won't have to miss 2 days of work?
yeah, if they're prepared to follow the supervision order, yeah. But if he doesn't have the interlock or he's not here, or they don't have it.
All right. Yes, Your Honor. Thank you, Your Honor.
Hey, Judge, I just want to talk to you a little bit about this issue. I've talked to the client. I've explained to him the question you're asking, and we've gone over the options once again. He's telling me he wants to plead guilty. I told him, hey, you don't have to plead guilty if you don't want to. The next step is we get a trial date. And what that would cause is your mom would come and testify. This is the evidence we have against you. And so at that point, he's like, no, well, I don't want her to come testify. Well, then what would you like to do? And he wants to plead guilty. And so I requested a competency eval. He came back competent. So.
Is he guilty though?
Well, that's what I talked to him about. I asked him, hey, here's the allegation.
Your Honor, on this case, as I said, we're still waiting on the writ, but we do have the 911 call that we have.
Have any other evidence as far as the guilt? Probably can go back there and show, hey man, this is what.
And we do have the body cams that we can review as well, but as of now, we're still waiting to talk to the complainant.
It's basically, Judge, the body cam where the sister and the mother are claiming that this happened, and the officer shows up and he's arrested based on their claims. And so I told him, hey, this whole thing is based on what they're saying. Your sister and your mom are saying that this happened. This is the evidence against you. And so I asked him, hey, do you want to go to trial? That's the next option. We got this plea deal, or we could go to trial. And he's telling me he doesn't want to go to trial, that he wants to plead guilty. And so
back out and try again?
We could try again, but I just wanted to let you know where I'm coming from. He came back competent. They say he's understanding on his decisions. He's more lucid now since he's been in for a while.
And it's gonna take
But then
another
it's gonna
30
take
days.
longer and he's getting out today, Judge, and he tells me he wants to get out today. He tells me he doesn't want trial. He wants to get out today. He wants to plead guilty. He did tell me those things, so.
Let me ask you this, is he pleaded guilty just to get out when he's really not guilty?
Well, at that point, I asked him, hey, the next step is going to trial, and he doesn't want to go to trial. He doesn't, it sounds like he doesn't want his mom to come testify. I mean, my concerns were, hey, does he really get it? I'm concerned now because he's going back and forth within 5 minutes. He just changed his mind 3 times within 5 minutes, and I don't know why.
And T-Raz?
The thing is, he's getting out today, Judge. Even if we get him T-Raz.
We can expedite it. I mean, we can have it done by Friday.
He's telling me he wants to get out today. I would try again. I just want to give you a heads up on where we're coming from.
If he's gonna tell me that he's not guilty, I'm not gonna take it.
No, I understand that. I understand that. And that's why I asked him 3 things. I told him, hey, this is the evidence we're facing. Do you want to do this deal? You don't have to do this deal if you don't want to, but the next option is we go to trial. And he's telling me he doesn't want to go to trial. It sounds like he wants to do this deal. He wants to get out today. And so I would say, let's try again. I don't know why that went the way it did, because we talked about it before and that was kind of unexpected. So that's why, I don't
It's
know.
not the first time.
Yeah.
And the last time.
Yeah.
And we have, actually, we've spoken to one of the witnesses. We just haven't, there were 2 people there and we've spoken to the witness. We just haven't been able to get in touch with the complainant herself.
Think she's ducking and dodging?
I'm not sure, Judge. She's a Spanish speaker. We tried calling several times with the Spanish translator, but
All the more difficult. Mr. D, what you got?
Yes, sir, Your Honor. May I approach
Yes, sir.
Mr. Adam Cope?
Oh, Mr. Coe. How's Mr. Coe?
Our probation officer has more information on him than I do, Your
How's
Honor.
Mr. Coe?
Well, so it looks like they staffed the case with Judge Guinea, and she wants to put him in SATF, but his next court date there is November 25th.
I think it's a good idea. I'm surprised they haven't sent him to, I'm surprised they even want to, like,
Looks like they went back and forth quite a bit.
with what? Prison? Or,
It looks like the first offer was time served. Then the mom appeared to be in court. She pleaded with them to give him treatment. They T-Razed him. They recommended SATF.
Okay.
And then he signed the many conditions for it.
Michael, what do you want to do on that? Because I guess we would be the holdup on it then. You want to take a look at Cope?
Yes, Judge.
Please, because it looks like they want to send him to SATA, but our DWI is holding it up.
Adam Cope, Judge.
Yeah. So it's extensive. You got to take a good look at it and let me know what you want to do. Okay. Luis. I don't know what happened at your house. You're charged with assault. I don't know what happened. I wasn't there. Ricardo wasn't there. Alex, you and your family only are the ones that only know what happened. I don't want you to plead guilty if you're not guilty. It's not a game. There are lots of issues that can arise in the future if this happens again. That's why it's very important. Are you guilty of the assault?
Yes.
You sure?
Yes.
Okay. The assault will go on your record and it will be there forever. And like I said before, there's an affirmative finding of family violence. If you get angry again, they can charge you with a felony because they can use this case to make it a felony. And then you're looking at a minimum of 2 years in prison, a maximum of 10 years in prison. You can never have a gun as well. or weapon or ammunition. Do you understand?
Yes.
Okay. You don't want a trial, right?
Yes.
You don't want to talk to the witnesses, correct?
Yes.
No one is forcing you to do this, right?
Yes.
You're doing it voluntarily,
Yes.
okay? You also, if you are not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, or denied naturalization. Is he a citizen?
My understanding is he is born here in Texas, I believe.
You are a citizen?
I think that in Houston.
Naciste aquí.
Yes.
Okay. One more thing, you give up the right to appeal. So once we are done today, you can never try to change this in the future. You understand?
Yes.
Will you do me a favor? Take the medication. When you do, good things happen. We don't like to see you in jail. Be nice to your mom. It's not hard. If you get angry, go outside and hit a tree. Go run, exercise, but be nice to your mom. She loves you and she wants you home. Okay? All right, good luck, Mr. Harper.
Thank you,
All
Judge.
right, thanks.
Judge, this is getting on your t-shirt.
I know, I'll do it now. Thanks. Guys, we're done. Have a wonderful day. I'll see you bright and early tomorrow morning. Let's see what happens tonight. Dun, dun, dun. Have all of you voted?
Yes.
Okay, great. Good. All right, bye, guys. We'll see you bright and early tomorrow morning. We love you. Thank you for hanging out with us, mods. Thanks again for a wonderful day, and we'll see you bright and early tomorrow. Go vote, and we'll see you mañana. Thanks again, mods.
All right, guys, gals, that's not the end of the show. Don't go anywhere. The Fleischer Forum tonight is presenting a special presentation of Judge Van cattle call, first call cattle call from Bay County, Florida.
Ms. Fambro.
Yes, sir.
Tim, are you ready?
Yes, sir.
Let's go.
Yes, sir.
I gotta go canvas.
On the X. On the X. Face the TV. Face the TV. Here you go. State your name.
My name is Aaron Wilson. Listen, you're fully court charged of domestic violence, cyber stalking. You understand that charge?
You understand what you're charged with?
No, I do not. You don't understand it? No, sir. Okay, it says that you repeatedly text messaging the victim over 50 times without a response. And text message, the defendant says, coming on over, you will see soon, jail is to shit. I have spent more time than most on OTW, which I take is on the way, strapped. I'm a soldier. While speaking to the victim, the defendant drove by the house at the time and noticed that law enforcement had been called to the residence. Shortly after that, he sent more text message saying, call the cops, you win. I double assault battery conviction. Although the defendant was aware law enforcement had been called, he never exited the neighborhood and was located by Sergeant Edwards about 4 streets down on Saratoga Place with his vehicle lights turned off. Sergeant Edwards detained the defendant and located a 12-gauge shotgun with a shell chambered in plain sight in the backseat of the car. Do you understand all that? Yes, I do. Okay. I understand you've been given copies of paperwork and advised of your rights. Is that true? Yes, sir. All right. Based on your application, you do qualify for the Service of Public Defender's Office. I'm going to go ahead and appoint the public defender to represent you. Any question about that?
Yes, sir, I'm not quite sure. You have to apologize. I have tinnitus. I do not hear very well.
He gave you a
appointed
public defender.
for you.
He gave you a public defender.
Okay, yes, sir.
Deputy, criminal history?
August of this year, 2 petty thefts and 2 contributing to the delinquency of a minor, and that's it.
Bonds 100,000, no contact directly, indirectly, or through a third party alleged victim, no access to firearms, no access to internet. Court date's gonna be November the 6th at 8:30.
That was 150?
150.
Yes, sir, thank you. Step to your right to the T. When the green light comes on, sign, sir, if you'll give us 1 moment.
Yeah, Morgan, you might want to check and see why that's not a aggravated stalking,
Yes, Your Honor.
especially with the firearm in the car.
Yes, say your name. Your name?
How you doing, Mr. Greenwood?
Yes, sir.
Mr. Greenwood, you fully court charged possession of burglary tools, burglary of a dwelling or business, and grand theft. Do you understand those charges?
No, sir. I
You don't understand the charges?
May I say something?
Sure.
Serious substance abuse problem after 17 years sobriety. And I'm service-connected veteran under the care of Dr. Fry and Millerton, Mississippi. And I'm trying to get into the hospital.
Okay. Based on your affidavit, you do qualify for the service of the public defender's office. I'm going to go ahead and appoint the public defender to represent you. So do you understand that?
Yes, sir.
Deputy, criminal history, Mr. Greenwood?
Nothing since 16, and that was a domestic. Prior to that, nothing since 2. Oh, 2.
All right. Bond said 2,500 on the possession of burglary tools, 5,000 the burglary of dwelling caused damage, 5,000 grand theft, no contact with your victim. Court date's gonna be December 2nd at 9 o'clock.
Well, I'm already on bond, sir.
Not anymore.
Yeah.
Red X, sir. State your name.
Mr. Bennett, you're fully court charged of operating a motor vehicle without a license. You're also fully court charged of trafficking methamphetamine over 28 grams, possession of oxycodone, possession of paraphernalia, and possession of butanidol. You understand the charges?
You understand what you're charged with?
Yes. I understand you've been given copies of paperwork and advised of your rights. Is that true?
Yes.
Based on your application, I find you do qualify. I'm going to go ahead and appoint the public defender to represent you, so you have an attorney now. Any question about that?
Yes, sir.
All right, the state has also filed a Nebia motion, which means that they are requesting that any source of bail money may be proven to be from a legitimate lawful source of income. I'm going to grant that request. Deputy, criminal history?
Earlier this year was an FT and a misdemeanor locally. Somewhere else in Florida, 22 battery, possession of crystal meth, and violation of pretrial. That's it.
Okay.
What was that about the bail? I didn't understand that.
Couldn't give you budget.
All right, your bond on the no valid driver's license is $2,500. Court date's going to be November the 6th at 8:30 in that case. On your other cases, your bond's $100,000 on the trafficking methamphetamine, $10,000 on the oxycodone, $1,000 on the paraphernalia, and $10,000 on the butanidol. Your court date will be December 12th, 9 o'clock at random UAs. Good luck, sir.
Step to your right to the T. When the green light comes on, sign next. Red X, state your name.
Daniel, person here. Person in your report on an out-of-county warrant out of Walton County. Looks like a grand theft charge between $10,000 and $20,000. Judge Green has requested the honor of your presence. We're going to honor that request, hold you for Walton County. Have you transported over there as soon as possible. You got a couple weeks out. Give me a Friday. $15th. All right, November 15th is going to be his return date if he hadn't already been transported.
Yes, sir. Step right to the T. When the green light comes on, sir. Red X, ma'am. State your name.
Ms. Dickens, how you doing, ma'am? Ma'am, before the court charge of possession of meth, possession of paraphernalia, and trespass. You understand the charges? Yes, no, maybe? Okay. I understand you've been given copies of paperwork and advised of your rights. Based on your application, I find that you do qualify. I'm going to go ahead and appoint the public defender to represent you. Any question about that? Yep, your criminal history, Ms. Dickens?
22 controlled substance, FTA, 21, there was a FFJ on a controlled substance on a FTA. Before that, nothing since 10, and that was a petty theft and a DUI.
Bond set at $7,500 on the meth, $1,000 on the paraphernalia, $1,500 on the trespass. No contact with the alleged victim, random UAs. Court date's going to be December 2nd at 9 o'clock.
All right, step to your right to the T. When the light comes on, sign. Next. Red X, ma'am. State your name.
Ms. Jones, for the court charge of driving under the influence. You understand the charge, ma'am?
Understand what you're charged with?
Yes.
I understand you've been given copies of paperwork and advised of your rights. Is that true?
Yes, it is.
Based on your application, I find you do qualify. I'm going to go ahead and appoint the public defender to represent you, so you have an attorney now. Any question about that?
No, sir.
Yeah?
No history.
What brings you down here from Georgia, ma'am?
I'm in nursing school and I was just celebrating with my friends. So we took a day trip to Panama just to get away from Albany, Georgia.
Okay. How bad's the car? Y'all seen the car? Total? Okay. All right. Nobody got hurt, right? Okay. All right. All right, Ms. Jones, I'm going to release you on what's called pretrial. They're going to release you today. Your court date's going to be tomorrow morning, November 6th at 8:30. And you need to report the pretrial release after court tomorrow.
Okay. Yes, sir.
All right, step to your right to the T. When the green light comes on, sign. Next. Wait for the light. The little white tab will turn green. Look up. State your name.
Brooke, here.
Ma'am, before the court term, violation of probation was originally a possession of methamphetamine and a failure to appear for retail theft. Do you understand those charges?
Yes, sir.
All right, ma'am. Do you qualify for the public defender's office? I'm going to appoint the public defender to represent you. Judge Gay is where you have without bond on the VOP. Your court date is December the 4th at 9 o'clock. On the failure to appear for retail theft, your bond's been set at $5,000. Your court date will be tomorrow morning, November 6th at 8:30.
Step to your right to the T. When the green light comes on, sign. Next. Red X, sir. State your name.
Eastwing Richard. Eastwing, you're fully court charged of cruelty to animal. Do you understand the charge?
I'm sorry, I couldn't hear.
You understand what you've been charged with?
Yeah.
I'm aware of what the charge is.
Excellent.
I've been told.
I understand you've been given copies of paperwork and advised of your rights. That's true?
Yes.
Based on your application, do qualify. I'm going to go ahead. Got an attorney now.
I'm sorry, what's that question?
He's telling you you have an attorney now.
Okay, okay.
Deputy criminal history?
No history, sir.
Bond set 10,000. Court date's gonna be November 6th at 8:30.
Step to your right to the T.
I'm sorry.
Step to your right to the T. When the green light comes on, sign. Next. Gary. Step on the red X. State your name.
Mr. Gary, for the court charge trespass. You understand that charge, sir?
Yes, sir.
So you can copy the paper, your rights. Based on your application, if I do qualify, go ahead and appoint the public defender. Any question about that? Onset at 500, court dates tomorrow morning, November 6th at 8:30.
Step to your right to the T. When the green light comes on, sign. Let me see. Next. Mr. Gary, step on the T. You're fine. Oh, you're fine. Go ahead and sign when the light is. Come on in, Mr. Brooks.
Yes, sir.
Step on the X, state your name.
Stephen Brooks.
Mr. Brooks, full court charge of possession less than 20 grams of marijuana and driving under the influence. Do you understand those charges?
Yes, sir.
I understand you've been given copies of paperwork and advised of your rights. Is that true?
Yes, sir.
Based on your application, you indicate you're going to hire your own attorney or represent yourself. Is that how you're going to proceed?
I have an attorney. They just wouldn't do it at the beginning. Laura McCarthy is my lawyer on previous cases. So if she's available.
Okay. Deputy, criminal history?
21. He just got off probation for 2 counts, video voyeurism. 20 was ag assault, and that's it.
Bond said 2,500 on the pot, 5,000 on the DUI, random UAs, and alcohol. Court date's gonna be November the 6th at 8:30 on both.
Can I add something, Judge?
Sure.
I appreciate the officers doing their job last night, and I ruined 21 years of sobriety yesterday, like an idiot, and I apologize to the court and to the city of Panama City.
Well, thank you.
Step to your right to the T.
Yes, ma'am.
When the green light comes on, sign. No, there's a pen there. State your name, sir.
Jeffrey Bone, UHN.
Mr. Bond, you fully court charged with battery. Yes, in charge?
Yes, sir.
I understand you can give me copies of paperwork and advise of your rights. That's true?
Fiance.
What's that?
I'm sorry, sir. Did
Were you
say
advised
wife?
of your rights?
Oh, I'm sorry, sir. Yes, I have been.
I understand you've been giving copies of paperwork advising of your rights, and based on your application, I find that you do qualify. I'm going to go ahead and appoint the public defender to represent you. So you have an attorney now. Any question about that?
No, sir.
Deputy, criminal history?
He just got reinstated on drug offender with register. And this is the same victim from a previous case.
Case number?
24-902 CF.
All right, Mr. Bond, on the domestic violence battery bonds, 15,000, no contact directly, indirectly, or through a third party alleged victim. In case 24-902, I'm signing a warrant for violation of probation. Good luck, sir.
Thank you, sir.
Step on the T. Next, when the green light comes on, sign. Red X, sir. State your name.
Robert Robinson.
Mr. Robinson, you're fully court charged driving under the influence. You understand the charge, sir?
Yes, sir, I do, Mr. Mayor.
I understand you've been given copies of paperwork and advised of your rights. Is that true?
Yes, sir, I have. I just got one question for you, just so I'm clear. It's saying until 16 days from yesterday, basically, this citation would be a temporary driver's license as long as I go to 2230 Northeast Avenue and try to get the hardship. Is that correct?
Yeah, that's what's on the paperwork. Absolutely.
Okay. Well, yes, sir, I think I understand everything.
Okay. Based on your application, you make too much money to qualify for a public defender, but the law recognizes your financial situation may change, in which case you can reapply later. You also have the option of hiring your own attorney or represent yourself. Any question about this?
No, sir.
Yes, Mr. Robinson?
Nothing since 15, and those were fishing violations.
Say it again.
Yeah, good. Free trial release. No alcohol while you're on free trial release. Union Court to the pretrial release officer after court tomorrow morning, November 6th at 8:30.
All right, step to your right to the T. Next, when the green light comes on, sign, step on the X, sir, and state your name.
Gary Zdenek?
Sir, you're fully court charged with leaving the scene of an accident. Do you understand that charge?
Yes, sir.
I understand you've been given copies of paperwork and advised of your rights. Is that true?
Yes.
Based on your application, I find that you do qualify. I'm going to go ahead and appoint the public defender to represent you. So you have an attorney now. Any question about that?
No.
Deputy, criminal history on Mr. Zdenek?
No history.
$80,000 worth of damage. You know, cops are notoriously bad insurance adjusters.
They said 650. They said 650. There's a mailbox.
All right, man. Bond set at 1500, court dates tomorrow morning, November 6th at 8:30. Good luck, sir.
Step to your right to the T. When the green light comes on, sign. Next. Red X, sir, state your name.
Mr. Montes Rivera, you're fully court charged domestic violence battery as a second or subsequent conviction or charge. You understand that charge, those charges?
Yes, sir.
I understand you've been given copies of paperwork and advised of your rights. Is that true, sir?
Sir.
Based on your application, I find that you do qualify. I'm going to go ahead and appoint the public defender to represent you. Any question about that?
No, sir.
Yeah, criminal history.
I have him on bond.
Case number?
24-1992 CF. That's from July.
I talked to Betty Clark. She said she wasn't gonna revoke my bond because the charges for that bond right there, the charges for that.
She may
particular
not, but
case-
I am. You may have talked to the wrong person. Fines 25,000 on the new charge. Court date's gonna be November 25th at 9 o'clock with no contact.
I have a question. I have a question, sir. I have a question. I got court on the 12th for that case.
We'll get you there. Yeah.
So I'm saying I'm still finna be there on the 12th though for court? Okay, I'm just making sure.
We'll get you there.
All right, thank you.
Wait. Next, sign where the light is up there. Red X, sir, state your name. Here you go.
Is Mr. Brown?
Yes, sir.
Sir, you're fully court charged with tampering with the witness and grand theft of a motor vehicle. Do you understand the charges?
Yes, sir. These charges from 2022, Your Honor, I just released from
That's
DOC
correct.
yesterday. In the into the Bay County property. I was wondering if there's any way I could get ROR on these charges.
He gave me a bond for this.
Based on your application, you do qualify for the public defender's office. I'm gonna go ahead and appoint the public defender. You got an attorney
Yes,
now.
sir.
You understand?
Yes, sir. Thank you, sir.
Deputy criminal history.
I've been incarcerated for the last 29 months. So I'm just trying to spend some time with my family, maybe hire a lawyer.
22, dealing and stolen, burglary, false ownership, grand theft, criminal use of ID. 21, grand theft auto ×2, dealing and stolen ×2, FTA. 20, plea and elude, DWLSR goes back to 15. Seven similar charges.
I just completed pre-trial release before my arrest, sir, for 5 months. Passed every year now, they put for me and everything. I mean, I do whatever I need to go. I just can't afford a bond right now. I've been incarcerated for the last 29 months.
Well, I'm certainly not gonna let you out without a bond.
Okay. Can I get the lowest permissible bond?
Absolutely. Bond on the tampering with the witness is 5,000, no contact. And 5,000 on the grand theft of an automobile. Court date's gonna be December 2nd, 9 o'clock. Good luck, sir.
Thank you, sir.
Step to your right to the T. When the green light comes on, sign. State your name, sir.
Mr. McKay, you're fully court on a violation of probation for what was originally a grand theft auto. Do you understand that, sir?
You understand?
Grand theft auto. Is Mr. McKay? Yes, sir. You're before the court, it's a failure to appear for a violation of probation for what was originally a grand theft auto. Grand theft 750 or more. Okay. Yes, sir. But you didn't show up. Yes, sir. Yes, sir. It's all my charges are running together from what you sent to me yesterday for. They're all running together. I don't know why this is going through like this, but well, I'm on probation for all of it together, sir. Well, Judge Clark is the one that signed the warrant for failure to appear. Yes, sir. But remember, yes, I remember. If you remember yesterday, I come through here also for a failure to appear, Judge Clark, for the same. I'm on charge for failure battery and for grand theft. Right. I'm wanting to go to rehab, Judge, man. I'm court date, right? This is all going to be on the same day. They're all going to be on the same day. This is just an extra charge that you didn't show up for. But we just had to make sure you get everything put on the same date. So it's all going to be on November 20th in front of Judge Clark. Yes, sir. Yes, sir. I understand. It's not an extra charge. I got in trouble for failure battery, and then I violated my probation for that, and then I got for grand theft, and then they put it all together. They restarted my 2 years with those two together. I just don't know why they did it separate like this. I just don't understand. I don't either, but he signed separate warrants for the failure to appear for the VOP. Okay, but that means my rehab that I went to court for, but they've come screen me while I'm in here. Y'all see if they can do that? Yeah, they can still screen you. Absolutely. Well, they come do it here or what? I don't know what's going to happen with that. They'll screen you at the jail. Okay, can y'all make note of that or ask them or something? Well, that's really a Judge Clark issue, not a Judge Van issue. Well, they had already rehab my first court date. I didn't get to make sure. Sir? Did you fail to appear? To my second court date. Not my first court date. I didn't. I just never read my second. At your first court date, they made you an offer. Yes, sir. You didn't show up for your second court date. Yes, sir. I know this is going to shock you, but sometimes people get mad about that and they revoke offers and they change offers. So your situation may have changed now. I don't know. I don't know for sure. You may have a prosecutor and a judge that is very forgiving, and they might still keep that open. I don't know.
All right, starting where the light is. Next. Red XR, state your name.
Dylan Thompson.
Mr. Thompson, before the court charged of domestic violence battery with prior conviction, aggravated assault, deadly weapon, possession of a firearm by a convicted felon, and criminal mischief. You understand the charges?
Yes, sir.
I understand you've been giving copies of paperwork and advised of your rights. That's true, sir?
Yes, sir.
All right. Based on your application, find that you do qualify for the Service Quality Defender's Office. I'm going to go ahead and appoint a defender to represent you. So you have an attorney now. Any question about that?
No, sir.
Deputy Criminal History.
21 resisting, failure to register, hit and run, DWLSR, FTA, battery by a detained person, 19 felony bat with the release out of DOC earlier this year.
Your Honor.
Yeah.
I would just like to ask if I can please get a bond for these charges. I know it looks bad, but I am trying to change my life around, and you won't see me back in your courtroom, sir.
Okay, well, part of that's true because you're going to felony court, so I won't see you back in my courtroom.
Yes, sir.
And I will give you a bond. On the domestic violence battery with priors, bond's $25,000, no contact with the alleged victim. The aggravated assault with a deadly weapon, $125,000. The possession of firearm by convicted felon is $25,000, and the criminal mischief is $5,000. Court date's going to be November the 18th at 9 o'clock. Good luck, sir.
Step to your right to the T. When the green light comes on, state your name, sir.
Mr. Kipple, you're fully court on a violation of probation for what was originally possession of paraphernalia, attached tag not assigned, loitering and prowling, and driving while suspended or revoked. You understand the charges?
Yes, sir.
All right, so you've been ordered held without bond. Your court date's going to be November the 13th at 1:30. Good luck, sir.
Is there any way, Your Honor, can I ask you a question?
Yeah.
I've completed 6 hours of ADI course for my driving, and I have 3 children at home. They're with their nana. I was seeing, is there any way, which I don't know if you can do this or not, but is there any way so I can support my children? I'm trying to turn my life around and do the right thing. I was trying to see if we could do this with a bond, this VOP by chance.
I tell you what we can do. We can get a time machine, and we can go back in time to before you commit the new violations, so that you wouldn't be committing the same violations that you were on probation for with the new charges. We could go back in time and we could stop that from happening. That's how we could keep you from.
Step to your right and sign. That's a wrap.
Let's do it again tomorrow.
Well, then that happened. Ladies and gentlemen, come to that point in the show where I must say adieu. It's been a great evening. There we are. That's what I was looking for. Oh, hey, it sounds like a great idea, Mom. Let's do it again tomorrow, shall we, ladies and gentlemen? Let's all get together and watch some Judge Fleischer talk about it. Maybe even some Judge Van. I don't know. We'll have to see what happens. But ladies and gentlemen, for now, I'm going to say goodnight. And thank you for coming by and sharing your time with me and watching these court cases and chatting. Chat's been great. Love you guys coming out and talking the talk, watching the vids. It's all cool. But I'm tired. It's been a long night. I'm gonna shut it down. I'm not doing any Ferris Bueller day off thing. That's not gonna happen. But I am gonna say, come by tomorrow. 9 p.m. Eastern Time, 8 p.m. Central Time, and every night this week, and watch some Judge Fleischer with me on the Fleischer Forum. And Saturday, come by at 11 a.m. Central Time, 12 p.m. Eastern Time, and watch the Weekend Review. And we'll all be more informed about court cases and our neighbors and what people do when they get to court and the decisions they make and how we might make decisions differently. Keep ourselves out of court. Ladies and gentlemen, it's been great. Free Chuck. He doesn't deserve to be stuck. But for now, we're going to say goodnight. I'll see y'all next time. I'm your Lone Wolf Usul. I'm your curator for these videos. And I'm out of here. Free Chuck, ladies and gentlemen. Good night.